Is for you. All right, ready to roll?
Attorney Douglas Rand Peacock for the defendant homeowner, Douglas Bolden. May it please the court.
Okay.
I'd like to reserve at best 5 minutes for my rebuttal.
5 minutes, you got it.
This case comes as a foreclosure on a homestead property, and there's really three basic issues which we're appealing on. Two of which are in what we consider a defective letter that complied with paragraph 22 of the mortgage, which was a condition set forth by effectively by the banks or the originator when making this loan, and also the issue, finally, of did the plaintiff produce admissible evidence at trial showing that they actually own the note, which in this case is particularly relevant in light of the recent stream of cases from other districts, particularly the Fourth, where it's held that where a bank has brought forth a lost note count, which was done in this case, and the note that was attached does not include an endorsement of any type or any allonges or any other assignments that predate the filing of the case, there is an evidentiary hurdle that a plaintiff has to overcome to establish that they in fact held the note at the time of filing, even if they dropped.
Let me ask you this, Mr. If
Yes.
you're mentioning this, let me handle that issue first.
Sure.
Isn't it true that in this case that count was ultimately dropped?
Yes, Your Honor, as it was dropped in those other cases which I'm making reference to, and I apologize, I'll have to make a supplemental of the various 4th DCA cases. Whether it's dropped or not, the issue is not a fundamentally acceptable principle that the bank actually held the note. It filed a complaint, presumably, that someone looked at and said, we've lost the note. Now, maybe they did, maybe they didn't. They still would then have to come forward and produce evidence that they actually held the physical note prior to the filing. It had, and I will concede, had the note, had an endorsement in blank that was attached to the original complaint, then okay, then they had that to make a copy of it.
Okay. Couple of questions I want to ask you. The note was in blank, correct?
When ultimately filed with the court.
Okay. And then help me out. Wasn't it true that in the course of these proceedings that there was it wasn't objected to where there was a substitution of parties?
It wasn't objected to because in terms of that they have now had a new party in interest, but we had never dropped our position as to the original standing issue with that either of them held the note at the time of filing.
Okay, because that's the part that troubles me, quite frankly. When there was a substitution, and the substitution was granted, and there was evidence presented that that entity is in possession of the note, where is the wrong in this case?
Well, that's the part. There wasn't evidence presented that that party was in possession of the note.
Okay, help me out. So tell me what was presented to the court, and we're taking your second issue first then.
Of course.
Okay.
All that was presented to the court was an assignment around 2012 saying that the note had been transferred, its ownership assignment rather, had been transferred to Nationstar. So now they're a substituted party in interest. Nothing had been presented to show that Nationstar, at least nothing under oath, held the note prior to the filing.
There was no testimony presented on that issue?
No, Your Honor. There was no testimony presented. There was just, we have the original note, we have this it's endorsed in blank. And for the testimony, there'd have to be documentation showing that, because these witnesses aren't witnesses to the original, holding of the note. They look at a file, they brief themselves, they come in and testify. There's been no documents presented showing that there was any transfer of that note to Bank of America or Nationstar prior to the filing of this case.
Now, that was a flaw in the pleadings under your version. At the time your clients asked for pre-foreclosure mediation, is that true or false? The case had been filed and they said, let's do mediation.
Right.
And then my question is, who are the parties to the mediation if not the note holder?
Well, my client answered that pro se, and then we subsequently came in and then amended our pleadings to reflect what the records, after I as the attorney reviewed the file and saw the issues that were present there.
So you're saying, since he's pro se, that should not be construed as a waiver of that argument?
Well, the court allowed us to bring that argument of standing in, and it was never subsequently struck out. So to that extent, it was preserved.
Okay.
Let me go back to when the complaint was originally filed. I thought that there was a note that was attached to the complaint.
There was, but it was unendorsed, and there were no allonges. So it'd be no different than me coming forward and saying, I'm suing on a check made payable to you, but there's no endorsement on the back or other contract assignment saying that your interest in it have been transferred to me. Now, we know if I went to a bank teller, they would say, I'm not touching that. Likewise here, courts have upheld that the bank still has to at least present proof that whatever ownership of that note they had was established prior to them filing the case, regardless of whether the later count was dropped as to the lost note. If they suddenly discovered that they've lost, that they didn't lose it, then they need to present evidence establishing that they held it. They presented the conundrum that they put themselves into by failing to attach the note with the endorsement in blank when they filed this case. And given the fact that this is not a case of a Bank of America loan and now Bank of America is suing, this is New Century Mortgage. There's a definite gap between the plaintiff, Nationstar or Bank of America, and the originator, which they still have the burden of presenting evidence at trial to overcome.
Okay, here's one of the issues I guess I'm having concern with. You're making the allegations, a lot of these, you're making these statements before the court, but we do not have on the record on appeal any copies of any exhibits or anything that was below. How are we able to make that review at this time?
Well, that would be the position I'd have, which was the plaintiff, these documents that we were talking to needed to be submitted to the court at trial and made as part of the record.
Okay, it seemed, at least it's been alleged, at least based on the briefs that were submitted and based on the record that we have, that somehow the court, there are some exhibits that were introduced into evidence. We don't have that with us, so how can we review and make the determination that something was missing or something was not done properly? Don't you bear the burden to, especially if you're appealing this, to bring forward at least a complete record for us to review?
Well, Your Honor, that's part of the issue I'm saying, which is there was no other documents put forward. The only other thing, and again, this is not one of the issues we appealed on, was the payment history. And that was a two-part payment history, but then that proved to be otherwise.
No, I guess, there's certain trial exhibits that were somehow, when you review this, it appears that there were some trial exhibits, but we do not have that on the record. That was my question.
No, I can't point to trial exhibits that weren't put there. There was just, here's the note, which is in there, the original note, which was part of the court's record. They reference to the court's docket. There is the assignment to Nationstar, which was, again, part of the original file as part of the transfer of interest to substitute the party out. There was no other documentation submitted. All they've relied upon is the note endorsement blank that was submitted after the filing of the case. Okay. The rest of the testimony, to the extent it's there, was about the payments and that they've sent the letter, the paragraph 22 letter. And the plaintiff's answer brief also points out, does not deny the fact that that's the documents they relied upon. They point to, well, we had an amended verified complaint saying that we held it. Well, that itself is not evidence that they held. That's not admissible or sworn under penalty of perjury testimony that they actually held it at the time of filing. And if that's what the plaintiff's relying upon, then there is no proof or admissible evidence. Anything else the court relied upon would have been inadmissible hearsay evidence, as it would have had to have been based on other documents which the plaintiff did not produce.
Okay. And I guess there, and maybe perhaps there's a more question to the other side, but they're alleging that the original note with a blank endorsement was admitted into evidence. This is what they're alleging. And that because you failed to provide to us with a transcript of the trial or copies of the trial exhibits, how can you argue that their status as a note holder at the time of complaint was not proven? That's the issue that I want you to address.
Well, my argument falls on the record itself.
I understand that, but if we don't have the entire record, how can we review something that's not there?
I guess we're kind of coming at this at opposite ends.
All right. Help me out. I'm trying to understand your position.
Okay. My position is that where a bank initially files a lost note complaint, and they themselves raise the issue that this note's location is somehow at issue. And they don't have anything else to show that they held it with it endorsed or in some way enforceable by them. At that point, then they have the burden of producing something other than just the original note. The fact that the original note was produced in the evidence, that's fine, but that's like half the puzzle. And that's part of the position I'm at. I'm being forced to argue they don't have sufficient evidence when you're asking me, well, how do I know the evidence they submitted was sufficient or not? And I'm saying that's what they submitted, was the original note. And it by itself does not establish their holdership of it at the time of filing.
There was a hearing before the trial. I assume that there was a hearing before the trial court. Was there a court reporter there? Was a transcript there? Was there any evidence presented? Did they make their pitch to the trial judge? Anything like that that we could review regarding the propriety of everything that you're asking us to do?
I believe there was a court reporter there. I don't know if the transcript was ordered and it certainly was not put as part of this record. So from that, I'd have to concede that has not before the court at this time.
All right. Thank you, sir.
Can you tell us about the paragraph 22 letter, your first issue, why you believe that was inadequate?
Two issues there, Your Honor. One is we don't believe that it adequately or fully stated out that the person had the right to reinstate the loan. There is some language that they have the right to make it current on the default, but that seems to be vague and ambiguous as do they just make forward the $15,000 that's listed in the letter and that's enough to overcome the default at time of trial or prior to closing or all the amounts. And also it's vague. It doesn't say you have the right. It says you may depending on these other factors. Whereas the language of paragraph 22 clearly...
Was there anything in that letter that was inaccurate or misleading?
Well, that's the next part. Yes, sure.
The first argument is incomplete, and the next argument is it's inaccurate or misleading.
Well, inaccurate and misleading would be the argument that it says the person has the right to bring a court action to raise defenses. And here, if anyone were to go looking up or ask their attorney, hey, I want to file an action, a preventative action to stop a foreclosure, we'd tell them correctly there's no such thing under Florida law.
There's no such thing as what?
Such as in a non-judicial foreclosure state, you can't file a quiet title action or something else to try and prevent a foreclosure from going forward. You have to defend it in court, raise affirmative defenses, which is the language of paragraph 22.
Or a counterclaim, I mean.
But there's no, it says you have the right to bring a court action to assert the non-existence of default.
As I read the language in the notice, it says you may have the right to bring a court action to assert the non-existence of a default or any other defense you may have to acceleration of foreclosure. Doesn't that disjunctive mean you read each one separately and it informs the borrower you have the right to assert defenses?
Well, that's the problem, Your Honor. This is a consumer law provision, most likely required by Fannie Mae or Freddie Mac as part of these mortgages to get their federal backing. That's a separate issue. I'm not saying it's necessary here, but it shouldn't be misleading. The language of the paragraph 22 is very clear. You have to tell them that they have the right to raise defenses, not this disjunctive or.
Well, I guess that's my question is how is that misleading?
Well, to a layperson as opposed to the people in this courtroom, they may take that as you have the right to, you have to bring an action to either assert the non-default or raise any other defenses in the sense that you still have the burden of filing that court action preemptively. Go to court, pay your $400 to, I guess, $1,900, depending on how the clerk views these kind of actions, and start a claim.
So it depends on the definition of or?
It depends on the definition before that of does that requirement to do as stated here in the letter, to file a preemptive action require you to do all the things that follow. You can do one of the two afterwards, but you still have to file a preemptive action, whereas Florida law clearly, and the language, more importantly, of the paragraph 22 states the opposite, which is you just have the right to raise defenses in court. So what they've been told to do, they didn't. They put an extra burden on it that clearly was not required by the mortgage, in fact was pointed in the opposite direction. So consumers are led down a rabbit hole of, I've got to go find an attorney.
Well, I mean, generically, you're talking generically, but let's talk specifics. Was there any testimony below that said I was misled by this letter?
Well, that's not an issue of being misled, Your Honor. It's an issue of compliance.
Is there any testimony below that they didn't comply with the mortgage, or just you're saying it's a matter of law this thing about misled doesn't accurately inform me is irrelevant. We didn't need testimony. Since we don't have a record anyway, you're not going to go there. So you're going to say we need to reverse this and hold as a matter of law that notice was legally insufficient on its face.
Yes, Your Honor.
Okay.
And I will acknowledge there was no testimony regarding whether the person was misled or not misled.
I mean, you could have called an expert theoretically to say this didn't comply, and I'm an expert in banking rules and regulations.
However, Your Honor, contracts are read.
Well, it might have been helpful because it looks like the judge just used, the common sense approach that they believe the notice accurately would have been sufficient, may not have been ideal, may not have been perfect, but it's close enough.
I don't believe Florida law has encouraged the use of experts to interpret contracts. Contracts, in this case, we have the contract of the mortgage, and I'm going to give an example, which I think the court would have no problem if it were different things. If the mortgage has said, in 10-point font, bold, you will state the following language, and the person did not put it in 10-point font. Now, the homeowner was able to go get their neighbor with a magnifying glass and read the 9-point unbolded font and figure out what it actually said, and were able to otherwise not be misled by the language. We would still say that doesn't comply. It had a clear requirement of something you were supposed to say in the way you were supposed to say it. And that,
you're down to your 5 minutes, so you can keep going or you can save it.
that's the bulk of my argument.
Good morning, Heather Fesnack, and I represent Nationstar in this action. I think Your Honors have already addressed what is a concern in this case and where we are in the same position, because I was not at the trial, unlike Mr. Peacock. So we are in the same position in evaluating this case, and we are forced to review the limited record in front of us. And based on this limited record, we have to ask ourselves, could anything have occurred at trial that would provide competent and substantial evidence to support a finding of foreclosure for Nationstar?
Well, for example, what might have occurred to cure a defective letter, if the letter in fact was defective?
Your Honor, the borrower may have testified that he in fact was aware of his rights, which I think, to borrow a phrase, the proof is in the pudding. This has been a defended action since the very beginning of the case. He immediately retained counsel. He could have testified he wasn't at all confused. He knew he had the right to defend, because a defense is necessarily brought in response to a claim.
What do we make of that pre-foreclosure mediation request that was done apparently pro se? How does that relate to the proper parties or standing, if at all?
Well, Your Honor, clearly he was aware that the plaintiff had the right to enforce the loan, acknowledged their right to enforce the loan, because he was seeking a modification in those terms. So I think
and that's who he has to be mediated with.
Yes, exactly. He did ask to mediate with the plaintiff, and the initial plaintiff in this case, who is Bank of America.
Ms. Fesnack, can I say something? And the notice letter, and one of the things that quite frankly troubled me, there's a lot of typos that it was rather embarrassing. And I hope, whether it's your client, but words like bemused instead of because, I circled all those. The other one, you have the right, THO, as opposed to the right. And we're talking about an established entity. And then there's one more that jumped out. Becoming due, and instead of saying the word due, becoming clue.
And Your Honor, we're
pest due as opposed to past due. That's just sloppiness. So I would hope, does that take away from providing the appropriate notice? I don't think so, but it's just not appropriate.
I agree, Your Honor, and I think maybe some of those are from appellant's brief as opposed to the substance of the letter itself, when there was a cut and paste from the letter into the brief as opposed to the actual letter. But I agree that the letter should be as forthcoming as possible, and I don't think in this case the letter was in all inaccurate or misleading. I'm happy to address those points now.
Let's go through the letter. Number one, what is the requirement of the notice letters? To put people on notice of a default, to give them the opportunity to cure the default, and then to explain to them what rights, defenses that they may have. So I guess my question is, number one, what does the letter serve? Did it provide them the appropriate notice?
Yes, it certainly did, Your Honor. It provided them notice of why their loan was in default. It gave them an act required to cure, a time period of at least 30 days, and it gave them the right to reinstate after acceleration. It also provided them with information regarding their rights to defend the action. All of those things are present. All 6 points of the requirements of paragraph 22 are in fact there. With respect to the right to reinstate that the appellants have raised, the letter clearly says you have the right to cure the default after acceleration of the mortgage. And that is exactly how paragraph 19, which defines the right to reinstate under the mortgage, explains what that right is. It's the right to cure your default and pay the sums that are due and owing after acceleration to bring your loan current and stop the acceleration process. So that sentence clearly puts the borrower on notice. You do have the right after acceleration to stop the process by paying the amounts due and owing. It also refers to the fact that this is governed by the loan documents. So it indicates to the borrower, review your loan documents to see the exact steps necessary and criteria for reinstatement.
Would you agree that the term cure a default is more legal parlance, that as lawyers and judges we understand what that means, but a consumer might not know those code words, that it means if I do this, then the bad things are going to stop happening and I'll get back on track with my lender?
I would think that most borrowers understand what curing means, and I think also the fact that the sentence informs the borrower that the loan documents are governing that gives them the opportunity to review their loan documents, which they have reviewed and signed and as a contract they are parties to determine exactly what steps are necessary to be taken to reinstate. But I do think that this letter sufficiently provides the information required by paragraph 22. It adequately puts the borrower on notice, read in a whole, exactly like the Busquets case, which I know that this court authored. The Busquets case says, reading the letter as a whole in connection with the mortgage, does the letter adequately convey the information? Not does it exactly mirror paragraph 22. There's no magic words. It just has to sufficiently and adequately convey the rights of the borrower to the borrower. And I think this letter does that exactly. The next issue is whether the borrower has the right to defend this action. And as Your Honor pointed out, the letter does say you have the right to raise any other defenses you may have to acceleration or foreclosure in any context. So it clearly puts the borrower on notice. I would argue maybe it's more expansive because it informs the borrower you may have the opportunity to bring a court action here for various issues, but you also have the right to raise any defense in any context. And clearly, as we've already discussed, the borrower did, in fact, vigorously defend this action. We are in the appellate stages of a contested foreclosure that was contested from the very beginning. There's really no practical way the borrower can argue he wasn't aware he could defend this action because clearly he did. It doesn't put any extra burden on the borrower at all. In fact, it provides more options for the borrower.
And let's talk about, going back to Mr. Peacock's first, the issue regarding the note. I want you to have the opportunity to address that. He's taking the position a transcript is not necessary. We don't need to have a complete record because clearly that your client failed to make that proof. So why don't you go ahead and address that?
Thank you, Your Honor. This appellate court is being asked to overturn a finding of fact by a trial court without having any of the factual context, no idea which witnesses were called. We know what documents were entered, but we don't know the testimony that was given as to any of those documents. There are many, many ways Nationstar could have established Bank of America standing to foreclose at the time the complaint was filed. In fact, Nationstar witnesses have direct access to Bank of America records these days and have been trained in their practices and procedures. There are many, many ways that the testimony could have substantiated standing to foreclose. In addition to the fact, as Your Honor pointed out, the borrower has conceded that he waived his right to challenge that standing when he requested to mediate with the plaintiff. And the original note, endorsed in blank, was filed by the plaintiff, which is additional evidence of standing. Your Honor brought up the assignment of mortgage between Bank of America and Nationstar, which includes note transfer language. It says, together with the notes described therein, which is further evidence that Bank of America had the right to enforce the note and transferred that enforcement right to Nationstar. So these are all pieces of evidence that we know were admitted because the parties have conceded which documents were admitted, but we have no way of knowing what evidence was or was not raised. Maybe it was hearsay, but we don't know if opposing counsel objected to it. It may have been admitted, without objection. So without an actual trial transcript, it's impossible for this court to assume that the evidence wasn't, or the finding wasn't based on competent and substantial evidence, or there wasn't some other basis for the court making this finding, or that any law here was misapplied. This is the result of a non-jury trial. And the finder of fact resolved all of these contested issues and determined that Nationstar had the right to foreclose. And our objective is to look, we have to look to see whether there's competent and substantial evidence to support that finding. And I think here, based on the agreement of the parties as to the documents that were admitted and the limited record in front of us, we know that there was competent and substantial evidence. And certainly nothing has been presented today or in the record that would cause this court to overturn that decision without any knowledge of what was discussed or argued in front of the trial court. I would also like to note that ownership is not required here. Again, holder status is the standard, and we've already discussed the numerous ways that Bank of America established its holder status, Nationstar after that, and the numerous other ways it could have further supported that standing at trial. Nothing in the notice is misleading at all. I think we discussed that. If anything, it was clear that Mr. Bolden is well aware of his right to defend this action. And we, again, don't know what testimony, if any, was given as to the notice of default, the condition precedent, the borrower's interpretation of that notice. Does the court have any other questions?
Nothing for me.
Okay.
Thank you.
Thank you.
Thank you.
All right, Mr. Peacock, saved you 5 minutes.
All I'm going to do is just restate that my client's understanding of his rights are separate and really related to the argument as to whether or not the plaintiff complied with the requirements of their own contract prior to bringing this action. And as Your Honor pointed out, on this discussion we had as to how one interprets the or, that is what makes the whole statement questionable. There are two reasonable interpretations. You can either file an action or do this, or you can file an action to do this or that. Whereas the mortgage itself had very clear language, just informed them of their right to raise defenses. Then a party knows what they're dealing with. Then they know what they're going towards. These requirements are there the same as like the 10-point font, as I pointed out, so that consumers have a clear idea of how they're supposed to respond. We feel that this letter itself does not comply. Courts have thrown out these issues, and it's not a matter of if you want to go on even on substantial compliance does not say it's okay to tell someone to go do something, jump off a bridge where they're not required to. It may require them to walk to the bridge. It may require them to take a picture of the bridge. It doesn't say that as part of that you also have to jump off the bridge. And I make that because there's a real difference between defending a case in court and going out there and taking the expense and time of hiring an attorney or yourself to go and file an action. So I don't think that this language substantially complies with anything indicated, implied, or written in the paragraph 22, and therefore it's a defective letter. It's a requirement the plaintiff bank put on themselves prior to filing this action, and is one the courts have routinely upheld as failure to comply with it, substantial or otherwise, is a bar to the plaintiff proceeding or winning at trial. And with that, I conclude my argument.
Thank you.
Thank you.
Thank you.
Well argued. Have a good day. We're going to go to the next case, which is the Largo and Schroeder matter.